call.
Sorry? 5 minute call. Yes, Mr. Speaker, thank you. Mr. Speaker, I want to make a few points, but I want to start off by saying that this situation is one which is very sad. It is sad for the former Judge Wilson, who I think, I'm not a lawyer, I have eminent lawyers on my left and my right, my learned colleagues, but I know that he had a very good mind and a good reputation as a jurist, and it's sad to lose him. There was also some sadness in my point of view for the position that Saxmere have been put in as a result of the lack of disclosure in this matter, not only on the part of Mr. Wilson originally, but also subsequently on the part of the Chief Justice and the Attorney General. And I think that in this debate, I do want to say that I agree with my colleague David Parker about the inappropriateness of making a payout, but I think I disagree with him because he focused in particular on the amount of money. My view, Mr. Speaker, is that the judiciary would have been, and the court system in New Zealand would have been better served by letting this run its course, because at the moment there is a reflection on the Chief Justice and on the Attorney General in New Zealand for their involvement in this matter, and Sir, that is something which in my opinion, is not a good position to be in, and therefore my view is that if the process had been followed, then we would have had things which are clear. And I just want to make 2 or 3 points, and that is that the Attorney General, and before it I'm going to preface by saying that in the United Kingdom the Attorney General is not a member of the Cabinet. The Attorney General is someone who is independent, and in fact in New Zealand, in my time in Parliament, we've had an Attorney General who has not been a member of the Cabinet, and having some sort of independence in that way I think would be useful. But in this particular, although I notice my learned colleague on my left is not that keen on that approach, it might be that he covets both jobs. Mr. Speaker, the point that I want to make is that on the 25th of February 2009, the Attorney General filed a written submission in which he said, as Justice Wilson's statement must be authoritative on the matter, the Crown adopts his description of those interests. So what Mr. Finlayson did was to align himself with the judge and said that that is the correct position. Subsequently, on receipt of correspondence from the Right Honourable Sir Edmund Thomas, QC, he became aware of the fact that the Justice Wilson's description of his interests were not accurate, but Chris Finlayson did not do what was appropriate and file a corrective statement in the court indicating that he was aware of that. And neither, sir, was there a formal approach from the Chief Justice. Sir, the Chief Justice was now a matter of public record, was written to by Sir Edmund, and she replied to him that the matter is in hand. Mr. Speaker, what we don't know is how that was in hand and what she did. And the problem I have with that is that we have a party to the proceedings, Saxmere, who were totally excluded from the knowledge that apparently through an informal channel the Chief Justice was putting before justices, but, sir, she did not do it in a proper manner such that the parties to the case were aware of it. Sir, she should have done her job properly. The Attorney General should have done his job properly. In fact, he should never have filed the first submission because, as he made clear to Mr. Colin King and to the Prime Minister. He was either a close friend or a friend of Mr Wilson's, and so when he does that, he should not have been involved, and he should have asked a colleague to make those submissions. This is not a good day. Order. It's not a good period for the judiciary, and I hope that the matters can be clarified as soon as possible.